Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are going to talk about the federal prohibition against machine guns because there was a ruling that came out of the Sixth Circuit late yesterday. Had a lot of people running around freaking out. We've had a chance to sit down and digest the opinion. We're going to go through it with you because I think there's a lot to be learned here, not only about what happened here, but what we might be able to do a little bit different moving forward and why maybe this is, in fact, an impossible task. So today, let's spend a few minutes and let's talk about the Sixth Circuit upholds machine gun bans. Okay, before we get going too far down the road we're going down, let's remember that all the research for this video was done where? That's right, at GroundNews. Why? Because I like to be treated like an adult. I don't need someone telling me how to think. I just need somebody who's objectively going to give me all the stuff to think about. And when you have a news source that's going to scour over 50,000 independent news sources and then break it down with a bias distribution, headline manipulation, and everything else that you need to make up your own mind, then you are finally being treated like a big boy or a big girl from media. So if you're ready to finally get objective information, sign up today for a Vantage Plan by either scanning this QR code right there or just go to ground.news/Washington. Okay, America, we have talked about this issue before, and we're going to talk about it again, which of course is 18 United States Code Section 922, subsection O, the federal prohibition on people like you and me possessing machine guns. The case we're talking about today is United States of America v. Bridges. It comes out of the United States Court of Appeals for the Sixth Circuit, originating out of the state of Tennessee. Now, the first thing we're going to learn about this is, and they teach you this probably the first couple of weeks in law school, is that bad facts will always make for bad laws. Don't believe me? Well, if you want to know what brings this case before the court and the lack of sympathy that any court might have for Bridges, consider the following. Bridges was driving on a highway in Memphis, Tennessee when he almost struck a police vehicle. As police tried to stop him, he slowed his car, rolled down the window, and fired several gunshots. One bullet hit the police car and narrowly missed an officer's head. Bridges sped off, leading to a pursuit which ended when Bridges crashed into a concrete barrier. He crawled out of his car and officers arrested him and searched his vehicle. Okay, so what kind of machine gun are we talking about here? Well, during the search, police found a loaded Glock 23 40 caliber handgun with an attached switch, a device that allows a semi-automatic pistol to fire more than one round of ammunition with a single pull of the trigger. That's right, we're not talking about a long gun, something in the AR platform or the AK platform. No, we're talking about a Glock with a Glock switch. And then, just to make sure that they had no chance of winning this case, it comes out that Bridges' legal team does not contest that the converted pistol is a machine gun as defined by 26 United States Code Section 5845B. So, Allah Rahimi here, we do not have a sympathetic set of facts, and therefore that is one of the things that probably contributed to this ruling. Now, the other thing we need to learn is that pre-existing bad case law can be very difficult to overcome. You see, because there was a case that previously had addressed the constitutionality of this statute known as Hamlin versus United States. And that is a case that had been decided post-Heller. And I think the court here actually did a very good job of saying that, Bruin didn't really carve out a new test. It just made more explicit, more clear the test that was actually carved out in Heller. The problem is as we know, even though we may have post-case law such as Bruin, since Bruin in many ways did just further announce and enunciate and clarify Heller, anything that relied on Heller likely is still good case law. And so the Court of Appeals was able to rule. Shortly after Heller, we decided Hamlin. There, we rejected a constitutional challenge to Section 922O, holding that Heller directly foreclosed it. Hamlin relied on Heller's statement that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. And it noted Heller's observation that it would be a startling interpretation of precedent to suggest that restrictions on machine guns set forth in the National Firearms Act might be unconstitutional. Thus, Hamlin concluded, whatever the individual right to keep and bear arms might entail, it does not authorize an unlicensed individual to possess an unregistered machine gun for personal use. The court also went on to then state, Hamlin, if it remains good law, forecloses Bridges' facial and as-applied challenges because it holds that the Second Amendment categorically does not protect the possession of an unregistered machine gun for personal use. So, bad facts, hard to overcome. Bad pre-existing case law, hard to overcome. Here's what else might be really hard to overcome, however, though, is the in common use test, because the court here, unlike many other courts who would just say, well, the plain text of the Second Amendment doesn't even cover this, the court here did a pretty accurate analysis, finding that, in fact, the possession of one of these arms is a bearable arm, and therefore the text of the Second Amendment would apply. It then moved on to the second step, which is there a historical justification for banning these types of weapons? And remember, when it comes to platform bans, we have actually already done the historical analysis. We use the common use test. And the only types of firearms that we can ban are those which are dangerous and unusual. And here's where things really fall apart for Bridges, because the court, for whatever reason, goes through an analysis of the dangerousness of a machine gun. Now, I have always stated that I believe all weapons are in fact dangerous, especially when they are in the hands of idiots. So there really is no reason to go out and make a finding of uniquely dangerous, but that's exactly what the court chose to do here. But be that as it may, the big problem is this, is they also made a finding that they were unusual. And the way they did the math here is going to be a big, huge hurdle. I want to explain what the plaintiff said, what the defendant said, and what the court ultimately ruled when it comes to numerical values, because that's how they wiggled their way out of this. Bridges asserts that there are over 740,000 total registered machine guns in the United States, and that the number in common use is even higher because we must account for unlawfully owned machine guns. Totally disagree with the last part of the statement, because the in common use test is in common use for all lawful purposes, and unlawfully owning them and possessing them would certainly not be lawful, okay? So Bridges is coming to the table saying, hey, there's literally 750,000 of them. But then here's where the United States government goes with it. The government responds that most of those registered machine guns are possessed by law enforcement, a category exempt from the possession ban and one that should not count towards guns in common use. Okay, you get that? They're saying, well, these are not owned by ordinary citizens for lawful reasons. These are owned by law enforcement for different reasons. So we exclude that from the calculation. What does that do to the numerical value? Excluding law enforcement equipment, the government asserts that there are around 175,977 registered machine guns, the number grandfathered into lawful registration before Section 922O's 1986 enactment. So, even though Justice Roberts and Rahimi said that we're not to take a look at gun laws trapped in amber, when it comes to the numerical value of automatic weapons in the United States for determining are they in fact in common use, that number is in fact apparently stuck in amber, and it is the date of the passage of Section 922O in 1986. So then the court goes through a long analysis and acknowledges Catano and talks about other cases that have delved into the numerical value of certain items that are being banned, but ultimately comes to the conclusion that given machine guns' lack of connection to lawful purposes, they are unusual under Heller. Okay, so that is how the Sixth Circuit has upheld 18 United States Code Section 922O's constitutionality. Now, if you think this is a bunch of liberal, renegade, agenda-driven judges, au contraire, most of them, in fact, were appointed by Republican presidents. So this begins to show you, America, that if there's ever going to be a significant challenge to the constitutionality of 18 United States Code Section 922O, we got a long way to go. We got a playbook that needs a lot more development because right now, especially if we just use this numerical value and trap it in amber, unlike how we're supposed to analyze the history of gun laws, apparently, there will be very few, if any, courts that will ever find that these are actually quite usual and in commonplace, and for that reason, it will fail on the common use test, and these bans will in fact be upheld. Okay, the case once again is United States of America v. Bridges. We're going to link up the court's ruling down below so you can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, that information's down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.